Hi, this is Giles from Michalsons. Yesterday I gave a presentation to effectively the debt collection or debt recovery industry yesterday. It was a short presentation and it was difficult because I had to cover an overview of POPI within about 45 minutes. But really there were three key take-home points which I gave to the delegates which I think are really worth talking about again and reiterating. The first is that for debt collectors particularly, it's important to establish what role they're performing in the context of POPI. And the question really is, clearly the debtor is the data subject. The responsible party is often, for example, the credit provider, and the debt collector is usually the operator because they're processing personal information for the responsible party. But that's not always the case, and it's crucial to identify what role you perform in the context of POPI. Are you the operator or are you the responsible party? Bearing in mind that you can perform different roles for different activities. So that's the first key point. The second key point relates to account numbers. In the debt collection process, you've got to process bank account numbers. And POPI includes a definition of an account number, which is essentially a bank account number, but could also be a loan account number. It could also be a retail store account number. But essentially, the penalties for offences relating to account numbers are significant. If, for example, you don't comply with the conditions when it comes to account numbers, there's a potential fine of 10 million rand or 10 years in jails. So it is significant in terms of the penalties, and therefore our key take-home point, one of them, is that you should be focusing on protecting account numbers. The third key point is that POPI is not a consent-driven law. In many countries in the world, you need someone's consent in order to process their personal information. And that's not the case with POPI. POPI as a default doesn't require consent. There are some specific instances where consent is required, but the default position is that consent is not required. And in the debt collection type environment, it would obviously be absurd if the debt collector had to get the consent of the data subject or the debtor to collect the debt. It just wouldn't make sense. So that reinforces and shows you why that's not the case. So really those are the three key take-home points that I mentioned yesterday in the conference, particularly talking about how POPI relates to the debt recovery industry.